Today I want to share with you some informative tips on guardianships. If you have a family member that you anticipate may need a guardianship, then this informational video is just for you. A guardianship is a relationship created by a court between a ward, that is, the person who needs care, and a guardian, the person who provides the care. Guardianships are often used when, one, there is a child with an intellectual disability and that child turns 18, and for elderly parents that may be suffering from dementia. Additionally, guardianships are also used when someone has become incapacitated after a serious accident and they no longer are able to care for themselves. Wouldn't it be wonderful if someone handed you a checklist of everything that you need to know about guardianships? I get it. We both know that guardianships can be complicated. The rules that govern guardianships are found in the Texas Estates Code, and that seems to be changing all the time. You may ask, how will I know where to start? How will I know what questions to ask? Are there different types of guardianships? Well, if you focus on the tips that I share today, you will be well on your way to answering these questions. And that's good news. The more informed you are, the better choices you will make. So are you ready? The checklist that I will share today will cover some of the steps that you need to know about guardianships. So let's discuss the checklist. Here are a few things that you need to consider when deciding if a guardianship is appropriate for your family member. First, before a court approves a guardianship, it will want to know whether a lesser restrictive alternative to that guardianship has been considered. Stay with me, and I will discuss this alternative in more detail. Step 2. Once the alternatives to guardianship have been considered, then the next step will be to obtain a doctor's letter detailing the proposed ward's incapacity. With this letter in hand, you are now ready for step 3, that is, to file the application for guardianship. After your case is filed, the court will then appoint a court investigator who meets with the proposed ward and files a court investigator's report. That is step 4. Additionally, the court will appoint an attorney ad litem. This lawyer is appointed to represent the proposed ward, not you, the proposed guardian. So, you have completed step 5 and the case is now ready to be heard by the judge, right? Not so fast. Before the hearing, the proposed guardian must complete step 6. That is, the proposed guardian must show proof that they have completed a mandatory guardianship training course. Hello, I'm Jim Soto with the Soto Law Firm, a probate, guardianship, and estate planning law firm located in Houston and serving clients throughout Texas. You don't have to go through the legal process alone. My 25 years of experience will serve as your guide when you need it the most. At the end of this informational video, I will provide you with a link to my website where you can schedule a free consultation to ask any question that you may have. The tips applied today will help you understand some of the requirements needed to set up a guardianship under Texas law. So you ready? Let's go through the basic guardianship checklist in more detail. Step 1. The court will always want to know if a lesser restrictive alternative to the guardianship has been considered. And that is the key phrase, a lesser restrictive alternative. Why? Because if a guardianship is granted, the court may, for the ward on his behalf, lose many or most of their basic rights. Family members may no longer be involved in decision-making if they are not appointed the guardian. And establishing a guardianship can be costly. Therefore, a lesser restrictive alternative to a guardianship is generally preferred over a full guardianship. Examples of lesser restrictive alternatives could include: are joint checking accounts possible? Are there powers of attorney in place where an agent could help the ward with medical and financial decisions? Is there a special needs trust in place to manage the ward's money? These are just a few of the many alternatives that the court will want to know have been exhausted before it will order a guardianship. Okay, let's move to the second step in the checklist, which is a doctor's letter. This doctor's letter is not simply a letter written on the doctor's letterhead. It is a certificate of medical examination that details the proposed ward's incapacity. This document is time sensitive. It must be filed with the court within 120 days from the time the guardianship application was filed. The third step on the checklist is filing the application for guardianship. In the application to the court, you must specify whether you are applying for a guardianship of the person, a guardianship of the estate, or both. If it is a guardianship of the estate, be prepared to post a bond. Step 4. After the application for guardianship has been filed, the court will then appoint a court investigator who meets with the proposed ward and files an investigator's report. These are the things that the proposed guardian must do as well. As of 2018, all proposed guardians must take a guardianship training course. This is step 5. The course is online and it is free. You must take the course. No course, no hearing, no guardianship. The sixth step to consider on your checklist is that at some point before the hearing, the court will appoint an attorney ad litem. In Texas, attorneys ad litem must go through extensive training and obtain certification through the State Bar of Texas before we can be appointed to represent a proposed ward. An attorney ad litem is appointed to represent the best interest of the proposed ward. The attorney ad litem does not represent the proposed guardian. If all of this is in order, then you are now ready to set the hearing and get ready to be heard before the judge. So, moral of the story, there is a lot to consider before applying for a guardianship. Take the time to go through the checklist and determine if a guardianship is appropriate for your family member. So there you have it. Those are the 6 steps that you can consider to understand the basics of how a guardianship is established in Texas. Let's recap. 1. Is there a lesser restrictive alternative to the guardianship? 2. Obtain a doctor's letter. 3. Review the court investigator's report. 4. Complete the guardianship training course. 5. Meet the attorney ad litem in your case for sure. And 6. Attend the hearing and adhere to the court's instructions. To get you started, I've set aside a free legal consultation to answer any questions that you may have. So make sure you go over to my website and schedule your free consultation. I will include a link on this video as well. Remember, you don't have to go through the legal process alone. Step by step, I will serve as your guide. Call me. I look forward to meeting you.